We are going to appoint justices of the United States Supreme Court who will uphold our laws and our Constitution.
With the death of Antonin Scalia on February 13, 2016, and the Republican Senate majority's refusal to consider Obama's nomination of Merrick Garland, the 2016 election became in part a referendum on the future of the Supreme Court. Would Scalia, one of the most conservative members of the Roberts Court, be replaced by a similarly conservative justice, or by a justice who was ideologically left of center? While a majority of the population voted for Clinton, due to the geographical distribution of the vote and the historical oddity that is the Electoral College, Trump comfortably won the election. Donald Trump is now the 45th President of the United States of America. As President, he has the constitutional power to nominate and appoint justices to fill vacancies on the Supreme Court. During the election, Trump released a list of 21 potential nominees, stating, "This list is definitive, and I will choose only from it in picking future justices of the Supreme Court," seeming to imply that he used the list for any and all possible Supreme Court appointments during his presidency. Trump could very well not follow through on that promise. He certainly has no legal obligation to stick to the list and could easily venture from it. But the list does serve as a good gauge for the type of justice that a President Trump would be considering. 6 of the names on the list come from the Heritage Foundation, a conservative think tank that first came to prominence during the Ronald Reagan administration. The rest of the names on the list come from the Federalist Society, a conservative libertarian organization of judges and legal scholars that seeks to promote a textualist or originalist interpretation of the Constitution. They view that the Constitution's meaning was fixed at the time of its enactment, that a law's meaning in ordinary language should govern its interpretation, not inquiries into non-textual sources such as the problem the law was intended to fix. For example, a textualist might argue that the First Amendment doesn't apply to executive actions. The text of the First Amendment states that Congress shall make no law to infringe upon the freedom of religion, the freedom of speech, or the freedom of the press. Thus, a president who issues an executive order that limits free speech or freedom of the press isn't technically violating the First Amendment. Just the fact that the names on the list come from the Heritage Foundation and the Federalist Society is probably enough to draw praise from conservatives and criticism from liberals. What might be more exciting for those on the extreme right and more terrifying for everybody else is the specific background some of these nominees have when it comes to abortion and gay rights. William Pryor once described Roe v. Wade as creating a constitutional right to murder an unborn child and the worst abomination of constitutional law in our history. As Attorney General of the state of Alabama, he offered a brief for Lawrence v. Texas that states, "A constitutional right that protects the choice of one's partner and whether and how to connect sexually must logically extend to activities like prostitution, adultery, necrophilia, bestiality, possession of child pornography, and even incest and pedophilia." Charles Kennedy helped coin the term partial birth abortion when he introduced a bill to the House of Representatives that eventually made them illegal. He voted for the Defense of Marriage Act, saying, "I really can't imagine how anyone could, in good conscience, oppose the proposition that the state should be able to deny the status of marriage to same-sex unions." As a current U.S. Senator, Mike Lee is involved in several attempts at anti-gay legislation. In 2014, he introduced the State Marriage Defense Act, which would give states the power to decide which marriages they would and would not recognize. In 2015, he was the lead sponsor of the First Amendment Defense Act, which would allow businesses with religious objections to marriage equality to deny goods and services to same-sex couples. In Christian Legal Society v. Walker, Diane Sykes wrote that student groups have a right to continue receiving government funding even if they refuse to comply with rules prohibiting anti-gay discrimination, because, as Sykes argued, their membership rules only exclude those who actively engage in homosexual behavior. As Solicitor General for Colorado, Timothy Tymkovich represented the state when it was sued for violating federal law by denying Medicaid-funded abortions to eligible rape victims. Tymkovich lost that case, but later argued in front of the Supreme Court for Colorado's law that removed legal protections for the rights of gays and lesbians. To be fair, some of the nominees on Trump's list have used their positions to protect abortion or LGBTQ rights. William Pryor joined a 2011 opinion holding that a government agency violates the Constitution's equal protection laws if it fires a trans employee because of their gender nonconformity. Diane Sykes helped strike down Indiana's 2012 attempt to defund Planned Parenthood. Neither of these actions are especially reassuring, given the previous track record of Pryor and Sykes, but they are at least something. Ultimately, though, if you care about gay rights, if you care about women's rights, if you care about human rights, Trump's potential nominees should shock and frighten you. Luckily, in the short term, by simply replacing Antonin Scalia, none of Trump's potential nominees will change the current balance of the court. Antonin Scalia was incredibly conservative, and replacing him with another conservative justice should not reverse any of the court's recent decisions. It will be more of the same, a closely divided court that overall leans right, with the deciding vote often belonging to Justice Anthony Kennedy. If Trump is able to nominate more than one justice during his presidency, though, the court might dramatically change. The Supreme Court case that legalized gay marriage was decided by a 5-4 split. If any one of those 5 justices were to be replaced by someone on Trump's list, it would be possible for the court to reverse its opinion on gay marriage. Since 1971, the average age of retirement for a Supreme Court justice has been 79. Ruth Bader Ginsburg is 83. Anthony Kennedy is 80. Stephen Breyer is 78. If Kennedy decides to stay on the bench, they might not all survive to the end of Trump's presidency. The Social Security Administration tracks actuarial statistics for the U.S. population and produces period life tables that list the life expectancies and death probabilities for different ages. The numbers in these tables are not exact. They are calculated for the average American and do not account for factors like diet, exercise, and family history. But the tables do give a good ballpark estimation of the probability that someone might die in or live through a given number of years. Year by year, you can use the Social Security period life tables to calculate the survival probabilities for Ginsburg, Kennedy, and Breyer. They don't look good. The probability that at least one of them will die in the next 4 years is 56%. In the event of an 8-year, 2-term Trump presidency, the probability of one of them dying jumps up to 88%. Ruth Bader Ginsburg, currently the most liberal and oldest justice on the bench, has only a 74% chance of surviving the next 4 years and a 46% chance of surviving the next 8. Ginsburg is reportedly very healthy, but if she were to have a serious stroke, a bad fall, get in a car crash, be diagnosed with Alzheimer's, what would become of the court? It's frightening to think that the rights of millions of Americans literally depend on the health and well-being of 3 people in their late 70s and early 80s. This is not normal. Democrats will have little say in who will replace Antonin Scalia. With 48 Senate seats, Democrats will be able to filibuster any nominee they find completely objectionable. But ultimately, Republicans have enough senators and enough votes to choose whoever they want. Also, if really pressed, Republicans could just remove the ability to filibuster Supreme Court nominees. In 2 years, though, there will be another Senate election. Democrats' chances don't look great. Of the 33 seats up for election, 23 are currently held by Democrats, 2 by independent senators who caucus with the Democrats, and only 8 by Republicans. Of the Democratic seats up for election, 5 are from states that went red for both Romney and Trump, and 5 are from states that went blue for Obama but then went red for Trump. Only one of the Republican seats, Nevada, is from a state that voted blue for either Obama or Hillary. The remaining 7 Republican seats are from historically very conservative states. How likely is it really that Democrats will be able to win a Senate race in Arizona, Mississippi, Nebraska, Tennessee, Texas, Utah, or Wyoming? But still, there is a chance that Democrats could win the 3 seats they need to gain a majority. If they don't, or if Trump is able to win a second term, then the Supreme Court will almost certainly shift dramatically to the right and stay that way for decades to come.